S&C Holdings versus Trayvon Steins.
Good afternoon, Your Honor. Tracy Thomas, speaking on behalf of the plaintiff.
Right. Trayvon Steins, they are not present. How would you like to proceed?
Your Honor, Mr. Steins has paid in full according to my client, and I just emailed Ms. Weidling a dismissal on this file.
Okay. Very good. I'll take that. Case is dismissed. That's without prejudice. We'll sign that and everything. Thank you, sir.
Thank you.
Calls the case of S&C Holdings versus Andre Harris.
Ready, Your Honor?
Andre Harris, they are not present. How would you like to proceed?
Your Honor, we do have personal service. I'm wondering if I can take a default judgment and a money judgment.
All right. You indeed do have personal service. Raise your right hand. Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
I do.
Go ahead.
Your Honor, rent and fees to date to retain possession would be $2,479, and we would ask for a judgment in that amount.
Judgment to the plaintiff. That is by default for possession. Redemption amount in the amount requested with the writ issue in 10 days. And
Thank you,
I'll
Your
sign
Honor.
that judgment upon presentation. Thank you.
I will present it this afternoon. Thank you, Your Honor. Have a good day.
You do the same. Willow Ridge Apartments versus Kiana Williams. That matter is dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. Have a good weekend.
Oh, I'm sorry, sir. I didn't know you were behind something else on my screen. All right.
No problem. It's great to talk to a local celebrity.
Yeah, okay. Well, I guess you're welcome. All
right. Have a good weekend. Thank you.
Take care. You too. Sycamore Meadows versus Denicia McGuire.
Good afternoon, Your Honor. Carrie Zanin, P67390 on behalf of plaintiff.
I believe Miss McGuire is here. Hello.
Hello.
State your name.
Denasia McGuire.
All right. And where are we on this case?
You know, Judge, I got an email from SOS yesterday asking for the documentations again, the lease, the ledger, and the W-9 form. I did send an email to her as well this morning, but I have not received a response back. I do remember that Miss McGuire was supposed to pay towards the balance because I believe her portion was going to be $2,500 and she was to pay, and I don't have confirmation that she's paid that. So I guess I would turn the mic over to her.
I just got paid this morning. I was going to let you guys know that when I got off work, I would go making a $600 payment today. That's all I could get.
That's all you could get?
Yeah, at the moment.
Okay.
With my job, I only get paid twice a month.
Right. But we're saying, how much is owing?
$5,109. Court cost of $175.
$5,109.
Yes, Judge. Court cost of $175 for a total of $5,284, Your Honor.
All right. Ms. McGuire, is Amy here? No. How much was SOS going to give you?
When I talked to, I believe her name was Amy, she said it was $3,000 that they were.
3,000? Okay, so are you subsidized?
Yes.
Okay, that's why. Okay, so there's a 3,000. What's your monthly rent?
$468.
Okay. So here's going to be our problem. So let's see, you were on the 17th. So on the 21st and the 31st, you were on the 24th. Did you pay 1,000?
I wasn't able to.
Oh boy. And then the 30, and today you don't have the 1,000, you only have 6.
6 of it, yes. And I
Oh.
won't be able to drop that off until I get off of work.
So, Mr. Guire, here's gonna be the problem. If I'm at 52.84, basically 5,300, right? And you're gonna get the 3,000, but they're not gonna pay the 3,000 until you come up with the other 23.
Correct.
And then on top of that, I then have, you said 468. So I've got about another 470 that I've got to tack on to that.
Correct. All right.
Judge, I don't mean to interrupt. I think the numbers I gave you are incorrect. I actually think that it's $5,613. I think the number I gave you was before May's rent. So I do apologize for that. It's actually 5,613.
Okay.
Sorry,
Alright.
Judge.
No, it's okay. Ms. McGuire. Ms. McGuire, my problem is I don't know how mathematically this is even going to work. I mean, what do you, tell me what you see. I mean, how do you see yourself getting out of this? I mean, I don't, let me just say this. I think when you gave me the numbers on the 17th, I don't think you were trying to not tell me the truth. I mean, I think you thought you could do it. And it's not happening. So tell me what you think.
And try to do something by today, but I'm not sure.
You can try what?
I can try to do something today, but I'm not sure.
What? You all right? All right. When you tell me that, what do you mean you're going to try to do something? What are you?
I'll try to see if I can get some more money by today.
You don't get paid next until mid-June, right?
Yes.
And on that check, you're not going to, what's going to happen with that? I mean, how much is that check going to be?
I'm not sure. My checks are different.
Okay. Mr. Guire, regrettably, I think we've kind of come to the end of the road because I don't know how to make it work. What worries me is that, we have 3,000 sitting out there, but I got to get that other now to really 2,600. And I don't know where it's going to come from. Even if you pay the 600 you have today, then I'm at 2,000. But then tomorrow 470 clicks in.
I'm gonna go back up.
And so we've only really knocked off 130. So your next check though is the 14th,
15th.
15th.
Yes.
So you get paid the 15th and the 30th, is that?
Yeah, and if the month has a 31st, and I get paid the 31st.
Okay. Hey, Ms. McGuire, I don't have a choice in this thing. Okay. I mean, we kind of worked it through. Do you also, did you also have 400 from DHS?
Yes,
So that's waiting out there too.
yes.
So I really have effectively 3,400 of this amount waiting. It's just, I mean, it's the same thing, but there's. Amy, I'm glad you showed up. You probably can't give us an answer. Is there, but even if she has the funding, I believe she's supposed to get 3,000.
Yes, Your Honor. So 3,000 from SOS. However, there's a portion that needs to be taken care of where they're comfortable releasing. And then the part that I don't have more information about is what that arrangement is or.
All right. The court's going to find that there's no tribal issue. The court's going to enter a judgment for possession. The total redemption amount, the 5,613 was inclusive of cost, Ms. Zana.
It was not. 175 is due in cost, so $5,788.
$5,788. Okay, Ms. McGuire. I won't have the writ would normally issue the 10th.
I was thinking the 14th, Judge.
And I'm gonna go to the 17th, and the only reason is that a check for her comes the 15th.
Sounds good, Judge. Understand.
So a writ would issue June 17th. All right, so now, Ms. McGuire, I added some time onto that.
Thank you.
You're welcome. You have to make a decision of paying the 600 to the landlord, but yeah, I'm not going to tell you what to do, but you've got to come up with, really, it's effectively 27 with the cost of almost $2,800.
Correct.
So if you've got 6, you're going to need an additional 22 somehow or another.
Okay.
I've given you additional time. The only other option, and I don't know whether or not and can't promise you anything, the landlord's willing to work with you and set up a payment plan that I think would suffice. Is that correct, Amy?
Payment plan would be helpful. There was a payment plan and a COD that would be even more helpful.
Even more help. So it's a conditional order of dismissal, meaning that the case would be dismissed if there's a payment plan set up. I don't know how Sycamore Meadows is going to feel about that. I'm not going to get involved in that. If they want to convert this to a COD, I'm not going to have a problem with it.
Okay.
So that can happen, and Ms. Zanin would know how that would work if you work it out with your landlord. But I suggest that you get to them as soon as possible.
Correct.
Try to see if there's a way that can work it out so you can certainly access at least 3,000 of those funds to maintain your housing.
Okay, correct. I can try to go I can try to leave work early today and see if I can go. Stay close when I get off work.
Okay, and is your voucher a site-based voucher, or
I'm not sure.
you know, Ms. Zanin, whether she's site? It's not. You don't have a housing choice voucher, do you?
No.
Where you can move. I mean, your rent is subsidized through Sycamore, basically,
Yes.
right? Okay. All right. Well, you don't lose that, Ms. McGuire. Okay,
Okay, thank you.
do your best. And Ms. McGuire, I have to say, I hate doing this. You know that, right? And whenever you come in here, despite how bad things were going, I have to appreciate one thing about you. That is, you always had a smile on your face and hope in your heart. I could tell. All right. So we'll just hope for you.
Thank
Okay, Ms. McGuire, you take care of yourself.
Thank you, you too.
Gene Ratliff versus Alexandra Klombach and Randy Edmond.
Here, this is Jean Ratliff.
Okay, who's here? I've got Ms. Ratliff.
Randy Edmonds.
And Alexandra
Okay,
Kalmbach.
got it. Okay, and Mr. Fink, I'll be right back with you on
Yes,
your
sir.
case.
Thank you.
All right. This is a termination case. All right, Ms. Ratliff, what's your, explain what's going on.
I have asked since fall for them to vacate the house at 8491 Huron River Drive because I want to reclaim the property.
Okay, let me ask you this. Was there a lease on the premises?
No, there was not.
It was a handshake agreement.
It was a handshake
Oh.
agreement.
Gotcha. Okay. Ms. Kleinbach and Mr. Edmonds, what's your position on this?
She did ask us in the fall, but she said that it was the first of the year that we had to be out. But that was 2 days after we had a baby. We're not trying to keep the place. We just signed a lease a week ago. It's been really hard to find a place to live. I think we looked at like 100
okay.
places.
Gotcha. Okay, so let me ask you this. Are you saying you signed a lease to another place about a week ago?
Yeah, but we can't move in until August, 1st of August,
Whoa.
maybe the middle of July.
All right. And Ms.
I never
Ratliff?
said that I was moving out in March.
You told me the 1st of March that the house that you were
Okay,
going to
folks.
rent it would be empty. So August is way too late.
Ms. Ratliff,
Yes, sir.
looking through your paperwork, did you send them a notice to quit?
Yes.
Yes. It was written on the 10th and delivered to them on the 10th.
We have not done damage to the house, Nikki.
Yeah, I would like to know what
Hold-
damage we've done.
Folks, no, not hearing it right now. I'm dealing with something else.
Yes, sir.
Okay. Ms. Ratliff, there's a problem with your case,
Okay.
okay? All I have in my file is a letter asking them to leave.
Yes.
Okay. So, and I'm assuming you didn't send the state form to them advising them that, because I don't have it.
The form was supposed to be delivered from the 14th District Court, and it said received on May 17th.
No, that's the complaint.
Okay.
I'm talking. So the letter that you sent on May 10th, right?
Yes.
Okay. So a couple of things. You sent a letter to them on May 10th. You have to give them 30 days written notice by statute.
Okay.
Okay. So, and it needs to be on a form that complies with all of the court rules. It has to advise them of certain things that they can do, advise them of their right to an attorney. All of those things are on that form.
Okay, where do I
The
get that?
letter,
form?
pardon?
Where do I get that form?
You have to get it from you can get a copy from either the website, you can go to the state website, or you can come down to any of our courts and they can provide you that form. It's
Okay.
basically a 30-day notice to quit. Okay, so here's the problem with the case that you have right now. Is that the form that you sent on the 10th doesn't comply with what's required to be sent to a tenant. That's the first thing.
Okay,
Even if it did, you did not give them enough time on the notice, okay? Because you have to give them 30 days. You muted yourself. Okay,
Okay.
there you are. Okay, you follow me?
yeah,
So, and without getting into the technicalities, I will if you want me to, but I won't. I'm just going to tell you this is the way that it works. I don't really get what's called subject matter jurisdiction over the case to hear it unless there's a proper notice that's sent. By
okay,
statute, that's how I get it. If I
Okay.
don't have subject matter jurisdiction, I can't rule on the case. And so since I can't rule on the case by case law, the only option I have is to dismiss the case.
so then I have to go get those forms and file them.
And you have to get the forms, get them served. You basically have to start the proceeding again.
Okay,
But because this was a month-to-month tenancy in effect, you have to give them that month period by statute.
okay,
Got it?
got it.
Okay. Mr. Edmonds, Ms. Clembaugh, do you guys have any questions regarding what I've just said?
You said that she has to give us a month. What, before the proceedings start all over again?
She's got to start the proceedings again because the notice is invalid.
So I have a question. So it says on that we have to give them only a 7-day.
Who is this talking to
No.
me? I'm sorry.
I'm Jean's daughter-in-law. So it says
Okay.
it says in the paperwork on the court website that you can give a 7-day notice if they've can have extensive and continuing physical injury to the property. So the property there's the outside of it, there is stuff everywhere. So
Hold on. Okay, so let me explain a couple of things.
Yeah.
First thing is that has to be filed in a particular way.
Okay.
The information is correct and can be a 7-day if those are the circumstances. I don't have any proof of that in what I've got here.
Okay.
That's the first thing.
So what do we have to do for that?
The second thing is I cannot give you legal advice.
No, that's okay.
I know that sounds really messed up, but I can't give you legal advice. I can just tell you why I'm ruling on that, but I can't tell you how you should proceed. And I'd suggest that if you have some concerns about that, you may want to consult a lawyer.
Okay,
It's because we're moving out that the stuff's everywhere. I'm getting rid of stuff. We've been here for 6 years.
Sir, I don't know all of that.
Yes, sir.
Folks, I just have paperwork in front of me. You guys can tell me whatever. I just don't know. All I know is I don't have jurisdiction to hear the case. Because the court lacks subject matter jurisdiction, this case is dismissed. Thank you.
Okay. Yeah.
I don't know how to do.
Is where. Okay, so I'm gonna handle this. And then it doesn't make any sense. All right, court does call the case of People versus Teresa Scott.
Assistant Public Defender Natalie Tate or Miss Scott, who I believe
Was signed in, MDOC had her signed in and then they are not. And locked. So I'll adjourn the probable cause June 20th, 2024. And again,
perfect. Thank you, Your Honor.
bond continue. Thank you. Calls case People versus Chance Thomas.
Assistant Public Defender Natalie Tate with it on behalf of Mr. Thomas. Please state your name for the record, sir.
Chance Thomas.
Thank you.
Thank you, Your Honor. We are asking to set this for a preliminary exam.
Discovery is complete.
To our knowledge, Your Honor.
And would the people have their witnesses available the 11th? I'm sorry. All right, thank you. Preliminary examination in person, June 11th, 2024, 9 a.m. before myself. Bond will continue. Thank you. Court calls the case, People versus Zakora Thomas.
Water Assistant Public Defender on behalf of Ms. Thomas.
Good afternoon.
Okay, hello, what's your name? State your name, please.
Zakora Thomas.
Thank you. All right, what are we doing?
Your Honor, Mr. Ganacho just extended an offer today. I need an opportunity to discuss that with my client, as well as her options moving forward. If we could adjourn the probable cause conference, please.
That objection, probable cause conference will be adjourned June 13th, 2024, 9 a.m. Bond continues.
Thank you, Judge.
All right, thank you. Thank you, ma'am. Court calls case, People versus Hamad Williams.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Williams, but not with. Your Honor, Mr. Williams was here and was present. However, he was experiencing some medical issues and left to the emergency room. I would ask for an adjournment.
Okay. I was informed of that, made sure he got out of here. Probable cause conference will be adjourned June 20th, 2024, 9 a.m. or as the invite indicates, bond continue.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Myron Williams.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Williams, who's approaching now. Mr. Williams, will you please state your name for the record?
Myron Williams.
Thank you. Your Honor, we're asking for an adjournment. This is another case where we did not have discovery as of yesterday, but I would ask for an adjournment.
Okay, gotcha. Probable cause conference, June 20th,
Thank you.
2024, 9 a.m. Okay, thank you, sir. Thank you. Calls case, People versus Ashley York.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. York. Would you please state your name, ma'am?
Yes, my name is Ashley Michelle York, Your Honor.
All right, what are we doing?
Your Honor, this will be a waiver today to the circuit court.
All right.
Miss,
Is that correct, Ms. York?
Yes, Your Honor.
You understand that a preliminary examination is a procedure where the people would have to show by probable cause that the offenses alleged were committed and that she committed them.
Yes, Your Honor.
You understand that you will not have that hearing. You'll proceed to circuit court for further resolution.
I do understand that, Your Honor.
All right, people also waive the right.
They do.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Ms. Gaines.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, my client wishes to stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set
July 9th at 1:30 before Judge Conkey.
July 9th, 2024, 1:30. Court does call the case of the People versus Matthew Cooper.
Afternoon again, Your Honor. Dan Garrett on behalf of Matthew Cooper.
And I think somewhere buried in here is a plea form. Oh, you have it. Okay, so it's not in this stack of paper. Now, what's so interesting is, Ms. Tana, you wrote this, correct? Yes, because I can read it. So I do know that Mr. Childers didn't write it. All right, I have a plea form before me that indicates that the defendant would be pleading no contest to an added count for stalking, the 1-year offense. Upon his successful no contest plea to that charge, is that counts 1, 2, and 3 would be dismissed?
Correct. There's also an agreement for the record to 4 years of probation. The statute calls for up to 5 years, but this would be 4 years, no early termination. So
Agreement to 4 years probation, no early termination.
I'll confirm that, Your Honor.
All right, very good. May I have him sworn?
Raise your right hand. You solemnly swear in the firm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Matt Cooper.
All right. Sir, it is this court's understanding that you're going to plead no contest to the charge of stalking. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs and up to 5 years probation.
Yes.
Understand that? All right. Do you understand what a no contest plea is?
Yes.
All right, two things about a no contest plea. I have to make sure that you understand. It first means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. Do you understand that?
Yes, Your Honor.
All right. Understanding all of that, do you still wish to plead no contest?
Yes, Your Honor.
Mr. Guerin, the basis for the no contest plea.
Your Honor, potential civil liability.
And sir, to that charge, how do you plead?
No contest.
No, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Honor.
No? All right, please look at paragraph 5. There's a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
All right. Court has been provided and has reviewed the Eastern Michigan University Police Department report for their case number 227120. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea to count 4. I lost it. To counts 4, counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
July 17th at 10 a.m. before Judge Barr.
July 17th?
Yeah.
July 17th, 2024. What time?
10 a.m.
10 a.m. before Judge Barr. Court does call the case People versus Brian Finneran.
Elizabeth McCree, Special Appointed Assistant Attorney General, P 76926.
All right, thank you.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Finnerman. Mr. Finnerman, can you state your name for the record, please?
Brian Finneran.
Okay, what are we doing?
Your Honor, I'm asking for an adjournment. Mr. Finnerman and I were not able to speak before today. So just want to touch base with him.
All right. Any objection from the people?
No objection, Your Honor.
Cause conference will be adjourned June 13th, 2024, 9 a.m. or as your invite indicates, bond will continue.
Thank you.
Thank you. Court calls the case People versus Austin McNear.
The Water Assistant Public Defender on behalf of Mr. McNear is appearing by Zoom.
And Madam Attorney General is present. Mr. McNear, can you state your name, please?
Austin McNear.
Thank you. All right, what are we doing on this?
Mr. McNear will be waiving his right to a preliminary examination.
All right. Is that correct, Mr. McNear?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand that you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
And I acknowledge receipt of the information, waive its formal reading. My client would stand mute.
Defendant having waived formal reading, standing mute. Court 4.
July 8th at 1:30 before Judge Slay Monday.
July 8th, 2024, 1:30 before Judge Slay Monday. And court calls the case People versus Dondra Washington.
Assistant Public Defender Hannah
Elizabeth.
Apple appearing on behalf of Mr. Washington.
Yeah, go
I'm
ahead.
sorry, Attorney General.
Go ahead, ma'am.
No, it's fine. I apologize. Special Assistant Attorney General Elizabeth McCree, P 76926.
No need to apologize. Miss Apple stepped on you. So
That was my bad.
we all got it. It was her bad. All right. Go ahead. What are we doing on your name, sir?
DeAndre Washington.
Thank you.
Your Honor, if we could have an adjournment of this matter for further plea negotiations.
All right. Without objection, probable cause conference, June 13th, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you. And I think that's it for you, Madam Attorney General. Thank you so much. Good seeing you.
Thank you, Your Honor.
Court calls the case of the People versus Brittany White.
Good afternoon. May it please this honorable court, Kareem Johnson, on behalf of Ms. White. You should be present in the courtroom, Your Honor.
Your name?
Brittany White.
All right. What are we doing on this?
Your Honor, we'd ask the court to set the matter for a preliminary examination.
Is all discovery complete?
Yes, Your Honor.
People have their witnesses available on the 11th. Preliminary examination in person will be set June 11th, 2024, 9 a.m. That is before Judge Burke.
Thank you very much, Your Honor.
Bond continued. You're welcome. Thank you, man. Case People versus Neri Wafik.
Show Feaster, Assistant Public Defender, appearing on behalf of Mr. Tafik. Mr. Tafik, please state your name for the record.
Hamid Tafik.
Thank you.
Judge.
Thank you, Judge. We were here a couple of weeks ago where we were trying to figure out which direction we're taking this case. I've referred him to our social work division to try to come up with a mitigation letter. He is also a veteran, so I'm looking into all the different options for Mr. Tafik.
All right. And so you need more time.
We probably get
how much more time?
well, so we don't have to come back and ask for another adjournment. If we could do 4 weeks, that would be ideal.
How come Feaster doesn't want to come back?
I'm going to be here.
No, that's like the third time you said that today. That's the third time you said that. Up until right now, I liked you.
Oh, thank you.
All right.
I like you.
Fine. I'll give him the word. Probable cause conference, June 27th. Will that work?
Yeah, I think so. Yes, sir. Yes.
No, you sure? I can give another date if you want.
Yes, sir.
Or that'll work? Okay. That's about a month out. Let's see where we are at that point. June 27th, 2024. That's 9 a.m. or as your invite indicates. Bond will continue.
Let me have my best review.
Okay.
Thank you so much, Judge.
Thanks, sir. Thank you, Judge.
All righty. Thank you, sir. Call the case, People versus Marion Smith.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Smith. Ms. Smith, will you please state your name for the record? Marion Smith.
Hey, Mr. Twafiq, next time you come in, if you wanted to bring your service dog up with you, you're more than welcome to do that, sir. I mean, he's very good in terms of staying back there, but you don't have to leave him. I know how that can be. All right. You're welcome.
Thank you. Your Honor, we are asking for an adjournment, 3 weeks if the court would allow. We did provide the mitigation letter to prosecution. They need some time to review it and speak with the witnesses.
All right. Probable cause conference, June 20th, 2024, 9 a.m. as your invite indicates. Bond, Ms. Smith will continue. Court calls the case, People versus John St. Germain.
Mr. Sinatra. For the people. Kenneth Overwater, Assistant Public Defender, on behalf of, but not with, Mr. St. Germain.
Better please note the corrections bond violation report dated 5/29.
Yes.
Judge, I am aware of that. I did speak to my client yesterday regarding that. He indicated to me, first of all, that he did not have transportation here. I believe he resides up north. But he indicated he did not have transportation here. I take that back. I apologize. He resides in Whitmore Lake, but did not have transportation here. Additionally, he suffers from anxiety, and that has been particularly bad lately. So he has been unable to leave his residence. That is the basis partially for his inability to test, as well as inability to be here today. He indicated to me he also does not have the funds necessary to test on a regular basis. I did discuss with him his anxiety issues, and I strongly encouraged him to seek out psychiatric treatment for that so he could resolve these issues. He indicated that he is going to try to do that. I'd be asking the court to adjourn this matter so that he may resolve those psychological issues and then appear.
Bench warrant will issue for defendant's failure to appear. Given the testing and what was said also at the last hearing he was here, bond will be set in the amount of $50,000 cash surety.
Thank you, Your Honor.
Court calls the case, People versus Abdullah Sheila.
Portia Feaster, Assistant Public Defender. Mr. Silla, Mr. Silla, please state your name for the record.
Abule Silla.
Thank you.
Thank you, Judge. If the court might recall, Mr. Silla missed the court date and did a warrant recall, as this is the first PCC since that date. So we had previously referred him to mental health court, and I don't think that worked out for him. So we're trying to find a different resolution. If we could go out a couple of weeks, I can try to see what other options there are for Mr. Silla.
Probable cause June 20th without objection, 2024, 9 a.m. or as your invite indicates. Bond will continue.
Thank you very much.
All right. Court calls case People versus Emil Thomas.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Thomas, who is approaching now. Mr. Thomas, will you please state your name for the record?
Emil Thomas.
Thank you.
Your Honor, if we could have an adjournment to continue plea negotiations.
Without objection, probable cause June 20th, 2024, 9 a.m. or as your invite indicates, bond will continue. Court does call the case of the People versus Cooper Hahn.
Your Honor, Michael Vincent on behalf of Cooper Hahn is approaching, and it's really nice to see you in person.
You know, Vincent, just leave it alone. Thank you, and good seeing you also, Mr.
Yes. All right. State your name for the judge.
Hello, my name is Cooper Hahn.
Thank you, sir. All right, what are we doing?
We'd like adjournment for 1 week.
One?
Yes. I've already checked with Ellie. 1 week. That's what she told me. And
will 2 weeks work? You don't know.
He told me that he could not do 2 or 3 weeks, which is why he was requesting 1.
Yes, but we'll do 2.
Because that's what Ellie told him.
Exactly.
Thank you, Ms. Barossa. I'll give you 1 week.
Thank you.
Only. Probable cause conference June 7th, 2024.
And Ellie's supposed to have me ask you if could stay at 9 o'clock because I have stuff in the afternoon. If that's
Do
possible.
what?
Keep it at 9 o'clock for PCC.
You know, if Ellie wanted to ask us, she'd call us.
I will.
I think you're just doing stuff. What?
Thank you, Queen.
Okay, I'll let them take care of it, Mr. Vincent. All right.
All right.
Bond will continue.
All right.
Thank you. Court calls the case of People versus Tyler Drulette.
Good afternoon, Your Honor. Dan Garrett on behalf of Tyler Drolette.
Good afternoon.
You should have a signed waiver in your file.
Yes, I do. Sir, you're waiving your right to a preliminary examination?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Mr. Garrett.
Your Honor, waive reading and stand mute, please.
Defendant having waived former reading, standing mute. Court will enter not guilty plea as to both counts. Pretrial in this matter will be set for
July 9th at 1:30 before Judge Committee.
July 9th, 2024, 1:30. Bond will continue. Court does call the case of the People versus Takia. Is it Corelli?
Good afternoon, Your Honor. Marcia Pretty on behalf of Ms. Corelli, who is appearing via Zoom.
Ms. Corelli?
Yes.
State your name.
The court staff informed me that she was dropping in and out. I don't know if that's still happening or not. Okay, you hear me?
Is it going to be a plea?
Yeah.
There's no way this is going to work.
Right. May I respectfully ask for a 1 week adjournment so that I can make sure that her Wi-Fi and everything is working via
I'll
Zoom?
give you the 1 week adjournment, and if there's not going to be suitable Wi-Fi given everything, she's going to need to be here.
Just to be clear, the Wi-Fi, we can make sure we can test beforehand to make sure it works. But if that doesn't work, then she needs to be here. I just want to be clear.
That's what I just said.
Yep,
Sounded like
just
an
want to be
echo.
clear. Okay.
Probable cause conference will be adjourned June 6, 2024, 9 a.m. or as your invite indicates, bond continues.